to both. So we're going to start off with going through wills, and then I will go into trust. I'll explain the differences because many people don't know the difference between a will and a trust. And then I'll end by explaining the importance of powers of attorney. Okay, and these topics are super important right now, especially during this turbulent time, because, the news just said 200,000 people have already passed away from COVID. And I'll bet you majority of those people passed away suddenly without even having time for estate planning. And so now all of their loved ones and beneficiaries have to go through the probate system, which is a very complicated, expensive, and time-consuming system. So if you want to protect your loved ones and not have them have to go through this long, complicated, expensive system, then make sure you have your estate planning prepared well ahead of time before it's too late. So going forward, we're going to go into wills. So this is the official legal definition of a will. A will is a declaration of how a person wants his or her property distributed after death. So the main distinction that you should remember as we're doing this presentation.
Oh, Rosie, I'm so sorry. Couldn't get back to you until now.
Oh, did someone start? I guess they should have muted themselves. All right, we'll continue. So just remember this part, okay? After death, a will does not take effect until after the person has passed away. Nothing happens now, even when the will is drawn up. That's very different from a trust, which we will go into detail later, because a trust can take effect immediately. Don't have to wait for the person who created the trust to pass away. So why would someone want to prepare a will? Number one, you need a will because you want to tell your beneficiaries what they get when you pass away. If you have any real estate, if you have any bank accounts, any vehicles, any type of assets, stocks, bonds, CDs, all that, you want to specify who gets those assets, when you pass away. So that's where you specify the property distribution. You put it into a will. Another big reason is saving taxes. And we'll get into the details of how much money the government actually takes away from your assets in the probate process. A lot of money goes to pay government taxes, estate taxes. So if you have a will, you can actually reduce taxes significantly. Furthermore, you can name fiduciaries. So it allows for an executor, who is the person who is executing the will, to designate your beneficiaries. But also, if you have minor children, you can also designate who are going to be guardians of your children if you pass away before the children turn 18, and become adults. And also, you can waive a security on a bond. If you go through probate, the courts mandate a very expensive security, so you can actually bypass that with a will. And last but not least, you can also provide for disabled family members. You can treat those members as minors and designate individuals to act as guardians for those disabled family members, or have property distributed to those disabled family members. So there's a lot of advantages of wills. And a will is like very simple to draw up. So there's no reason why someone should not have a will if you own assets, because it's so simple and it will just save so much time, money, and expenses. But people just, they go on with life and they forget about it. So here are just some terms so you guys know, the legal terms I'm using, and, there's no confusion. I know a lot of people don't understand the legal terminology associated with wills. So we already went over the definition of a will. The testator, you'll hear that term come up quite often. The testator is the person who makes the will. So Elizabeth Yang's will, the testator will be Elizabeth. Okay, the beneficiary is the person, or you can even designate an organization to receive your property at the time of death. So a lot of people, if they don't like their family members, they don't want to spoil their children, they can list an organization, many times a charity organization or a nonprofit, to get all of their assets when they pass away. All right, so that's what a beneficiary is. Now going into the requirements for making a will. So the statute of wills is a law that requires wills to be in writing. Okay, a lot of people will think, oh, I can just verbally tell my children that they get all of my property when I pass away. Unfortunately, verbal promises are not enforceable in court. It has to be in writing, and it's got to be signed by the person making the will. Not only signed, it's got to have witnesses. Every state has different legal requirements. In California, you got to have 2 witnesses. 1 witness doesn't fly. And then also you need, the testator needs to have testamentary capacity, which means that they have to be of sound mental condition in order to sign the will. I just had a client reach out to me earlier this week saying, her grandfather has this real estate that he wanted to pass on to his 3 children, which was a daughter, the client's mom, and 2 sons. The mother passed away, and so only the 2 sons are left. But right now, that grandfather is in a hospital bed and has dementia. And they did not sign a will in time. So now at this point, it's almost like the grandfather has passed away. He cannot sign a new will because he does not have testamentary capacity. So this is a lesson learned. Do not wait until the last minute when someone is already on the hospital bed to start researching and getting this stuff done. Do it when people are healthy, because they need to have testamentary capacity in order to sign and execute a will. So here is the portion about witnesses. So most states require 2 or 3 witnesses, and the witnesses must also themselves be competent. You can't have a minor be a witness. You can't have a mentally disabled person be a witness. There's all these requirements. Minors themselves cannot be testators. They cannot create wills. And many jurisdictions say that interested parties like beneficiaries cannot be witnesses. So if one of the parties is listed in the will as a beneficiary, it's best that they are not a witness. California does not require that they're not a witness, but if you want to avoid any conflict of interest, avoid having interested parties be witnesses. Undue influence is another aspect that comes up quite frequently. So undue influence is when someone tries to take advantage of another person's mental, emotional, or physical weakness to try to force that person to make a will. A lot of times caretakers will try to force an elderly person, for example, to execute a will. So a lot of times this comes up in court because they will say, oh, the testator did not create a will out of their own free will. So make sure that whoever is drafting the will is doing it out of their own free choice, not under the influence, undue influence of any third party. Otherwise, it can be set aside later on and be deemed unenforceable. And finally, how do you revoke a will after it's been drafted? So the testator can revoke a will using many methods. He or she can burn it, tear it up, physically destroy it, in any way, shape, or means. Or the testator, if they cannot find the will and lost it, they can just execute a new will. And in the new will, it will have a paragraph that says all previously executed wills are void and unenforceable. And then the new will take into effect. So the courts look at the date and the date of the will, and they see whichever will was executed at a later date, that will be the one that's in effect. So these are the ways to revoke a will.
Elizabeth?
Yeah, you have a question?
Yes, I have a couple of people asking, how much does it cost to draw up a will?
So wills, it really depends on where you go to. Like, you know, if you just go to LegalZoom, you can get a very general template for like, I don't know, $300. But if you want a more customized one, an attorney usually charges starting at $1,500. And some people have a lot of assets. Some people have businesses and companies and even international assets that they want to put in there. So the exact price will depend on how complicated the assets are and the list of beneficiaries. But approximately, you know, $300 for like a template version that's not customized, or $1,500 starting for a customized version. Does that answer the question? Okay, great. Any other questions? All right, then moving on to this word intestate. What does that mean? So intestate means if someone passes away without a will. Okay, so if someone dies with a will, then the properties go to the beneficiaries that's listed. Very simple process. Someone dies without a will, first of all of those assets need to go into court, the probate court. And then the court will have to ask for all of the interested family members to be listed and show up, and then see how many interested parties there are. Okay, in California, the properties first go to the spouse. And if there is no spouse, then it will go to the parents. If there's no parents, it will go to the siblings. If there's no siblings, it will go to the children. And the list goes on and on. And if there are no heirs at all, then the deceased property will just go directly to the state. It's called escheat. Okay, so those are the order. So like my friend, you know, her mom passed away and the grandfather didn't have a will. So guess what? She's the granddaughter. I didn't say any mention of grandchildren in that list. So grandchildren, they're not going to get it, unfortunately, if there's no will. Nieces, nephews, cousins, all of those, they will not get it if a will is not drafted. All right, so that's what intestate means. All right, so that's all the information about wills. And I will now go into trust, because trusts are more complicated, but there are a lot more advantages to trust. Okay, so here is the legal definition of a trust. A trust is a fiduciary relationship with respect to property in which the trustee holds property for the benefit of another person, also known as, again, the beneficiary. Okay, so see how it's more complicated? There's more parties involved. So I have a visual for you that will help you visualize this. Okay, but before I show you the visual, let's go into the different terminology. So the settlor or the trustor is referring to the person who creates the trust. Now, in addition to the person who creates the trust, we now have a trustee. The trustee is the person that the trustor designates to manage the trust. So the trustee does not own the trust, but they do hold legal title because they have the ability to carry the terms of the trust out. So the trustor can actually name him or herself as the trustee and manage his or her own trust, or they can designate a third party. And beneficiary is the same as the will. Beneficiary are the people who end up receiving the property and the assets. So here is the visual that I was talking about. So we have in the green box, the settlor. The settlor is the person who creates the trust. The settlor gives legal title to the trustee, right? So the trustee doesn't own the trust, but they hold legal title and they manage the trust. And the trustee manages the trust for the beneficiary, for the benefit of the beneficiaries, which is in the blue box. And the beneficiary, in turn, has equitable title to the trust, which means that even though they don't own the trust, they have equitable title because the assets will eventually flow to them. It's just temporarily being held in the trust until some event happens. And that event does not have to be death. You can specify in a trust that, when my son gets married and has children, he can then have this house. You can designate a lot of different conditions. Whatever condition you want does not have to be based on death. All right, so this is the visual. You guys are welcome to take pictures. So here are the different trust advantages. Number one, just like a will, it avoids probate. All right, so if you have assets in a trust, same thing. You don't have to go through the expensive, time-consuming process of the probate court, and you get to help your beneficiaries save a lot of money. You also can designate guardians for minors in a trust so that you can avoid guardianship proceedings, and not just for minors, but also for disabled persons. Another advantage that trusts offer is privacy, and that's something that's different from a will. So if your family or yourself, if you have a lot of assets, like for example, real estate, any real estate agent can just go on the database and search the name and find all of the assets that's under that person's name. It's all public record. So if you don't want someone to know how much assets you own and you want to have privacy, you can have your properties not under your name on title, but you can put title as the trust. And a lot of people, like, they name their trust, like for example, they'll say, oh, this is the Elizabeth Yang Trust. But that actually destroys this advantage of privacy, because if someone sees a house that's under the Elizabeth Yang Trust, of course they will know Elizabeth Yang owns it. So you want to put your trust into a name that's not connected to yourself. Like some auspicious people will name it the Lucky 888 Trust, right? Or something that's like auspicious and brings money. A lot of Chinese people, they like their trust to have some kind of lucky name. And then people will see that name and they'll have no idea it's your property. And that's how you gain the privacy advantage. It does not go on public record, and you don't have to publicize the value of your assets. So that's the main reason a lot of people put it into trust, for this privacy purpose, because a will, you still have the property under your name. You don't have this privacy advantage. Also, a trust provides easier management in case of incapacity. So, God forbid, if something were to happen to you, like car accident or something, and you can no longer make decisions related to your assets. If all your assets are in a trust, your trustee can manage everything for you immediately. So you don't have to worry about it. It's, already taken care of, and you've already designated who does what, which asset goes where, and everything is easier and much quicker to manage. And finally, of course, the big one, tax savings. So tax savings, let's talk about taxes. All right. So there's 3 kinds of taxes that we have to pay. Number one, there is the federal estate tax. So when someone passes away, 40% of their assets go to the federal government. That's a lot of money. That's like almost half of everything you own. Okay. And then there's also state estate tax, and there's inheritance tax. Fortunately, because we live in California, we don't have state estate tax and we don't have inheritance tax. But if you have assets outside of California, many states do have an additional estate tax on top of the federal 40%. And these 6 states that I've listed on this slide also have a third inheritance tax. So pretty much at the end of the day, the majority of your money is going to the government. and you don't want your hard-earned money, to just be chopped in half. So that's why you have a will or a trust to save money. And how does it save money? Okay, so there's this thing called estate tax exemption. All right, and this number changes year to year based on what the government sets. So back in 2016, the estate tax exemption was $5.45 million per person. It was about the same in 2017, but in 2018, when Trump was elected as president, it all of a sudden doubled, more than doubled actually, and became 11.18 million per person. This year it's gone up slightly to $11.58 million per person. And what this means is that your first $11.58 million is tax-free. Okay, but you have to take advantage of it right now because we don't know what's going to happen in 2021, right? It's election year. We have no idea what's going to happen during election. If 2021 is still, 11.5 million, then, great. But what if it drops back to $5 million? Then you're going to lose out on like $6 million worth of tax exemption. So how do you take advantage of this $11.58 million? Well, you can establish a trust this year in 2020, have the assets be in the trust and have beneficiaries designated. And you can even, create a life insurance policy, which is what Francine's company does. You have a life insurance policy and you take advantage of this year's $11.58 million. And because it's already done this year, you don't have to worry about 2021 or 2022 or how this number is going to fluctuate in future years. Because if it goes down, you've already taken advantage of the tax savings for this year. And so if it goes down, you don't have to worry because you've already got the 11.58 million tax exemption this year. So this is huge, right? If this exemption keeps going up, then no problem. But we really don't know what's going to happen. So it's safer to take this tax savings this year than wait and see what's going to happen next year, right? The stock market is so unstable right now, the economy, we just really don't know what's going to happen next year. So if you have, enough assets where you want to protect it and not have half of it go to the government to pay taxes, then take advantage of this $11.58 million in 2020 before it goes away. All right, so that is that last tax savings advantage for trusts. All right, so now we will go into all the different types of trusts. There's a lot of different types of trusts, which I've listed on the screen, and we'll go through it in detail. Number one, there will be revocable versus irrevocable trust. And then there's also living versus testamentary trust. And there's also funded versus unfunded trust. So by the time we're done with all this, you will see these 6 terms and you will know what it means if you pay attention. So number one, revocable trust, otherwise known as a living trust, is probably one of the most common forms of trust. And a revocable trust is exactly what it says, revocable, which means it's changeable. So that means if someone puts property into a trust, you can change it anytime. You can take it out, you can add more property in, you can sell property, you can change the beneficiaries, you can change the trustee, you can change all the terms because it's called revocable trust. Okay, so most people will do a revocable trust because they want to have the ability to change the terms, to add assets, to remove assets. The other type of trust is the irrevocable trust. The irrevocable trust is not revocable. So basically it means once you set the terms, they are set in stone and you cannot change it anymore. You can still retain the power to make investment decisions, but you can no longer revoke it. So if the terms say that this house goes to your brother when such and such thing happens, that's it. The term will stay and it will not be changed. So why will people choose an irrevocable trust over a revocable trust if it's so inconvenient? Well, there's advantages. So an irrevocable trust is the only type of trust that will protect you in case of a litigation or a lawsuit. So a lot of people, they say like, oh, I'm in this lawsuit, and someone is suing me for all this money. I'm afraid that if I lose, then they're gonna take away my house, they're gonna put a lien on my property, and I'm gonna lose all my personal assets. So that's where the irrevocable trust comes into play. You put your assets into an irrevocable trust, and then it's protected. Creditors cannot touch it. Plaintiffs who sue you cannot touch it because it's no longer your property. It's now in an irrevocable trust that cannot be reversed, cannot be changed, and it's protected. So that's a big reason why people create irrevocable trust. They already know that these assets are going to go to either their kids or some family member, and they know they're not going to change their mind, and they know they're not going to make any changes. So it's set in stone, and you get an added layer of protection from litigators who come after you. So it's a big advantage, for people who are involved in litigation and lawsuits. Okay, so on the next slide, it will show how to terminate a trust. So a trust can be terminated if the settlor reserves the right to revoke it. All right, so for example, if your trust is irrevocable, but in the terms when you sign it, you say, this property will go to such and such person, but in 2030, I will be able to get it back. Then in 2030, when the time comes, then the trust is terminated and you will get it back. But you have to set those terms early on when the trust is created. Once it's created, you cannot add more terms to an irrevocable trust. Okay, so it's able to be revoked when the trust contains a specific termination date, or it will terminate upon the happening of an event. So those terms have to be put into place. A lot of people still get confused about revocable versus irrevocable trust. So I like to use the analogy of an Amazon package so you guys can visualize it. So for example, a revocable trust is where you put things into an Amazon box. You don't seal it, you don't mail it, it's just open. So you can still put more things in, you can take things out, and you can change it anytime, and you can change the recipient anytime. You can choose, you can say, okay, I'm gonna, send it to my brother in New York. Oh, I changed my mind. I'm gonna send it to my sister instead. Oh, I changed my mind. I'm gonna send it to my kids instead. It's not sealed yet, so you can change it anytime. An irrevocable trust is when you've already taped up the Amazon box, you've already put the recipient's name on it, and you've also already shipped it off. So once you ship it off, there's no turning back. You can't go to the post office and say, look, I want my package back. No, it's already been shipped off. So that's an irrevocable trust. Everything that's already in there, you can't add anything else because it's already been shipped off. Okay, so I hope that analogy helps you guys visualize the difference between a revocable trust and an irrevocable trust. Okay, do we have any questions about trust? Revocable or irrevocable?
I don't have any text message here.
Okay, great.
Okay, you're doing
That's
great.
good. Hopefully everything's clear because a lot of people get very confused with all these different terminologies. So moving on to the other terms of different trusts, this is a living versus testamentary trust slide. So you hear the term living trust all the time, right? Why is it called a living trust? It's the living trust because it's created when the settlor is still living. when the settlor is living, they can move their assets into the trust. They can change the title of their house to the name of the trust. They can do all different things when they're still living. Okay, so this is different. Remember when I was sharing what is a will? The will, by definition, contained the words after death. So the will is after death, whereas the trust can be a living trust. So that's very different, living versus after death. A trust, however, can also take into effect after death. In that case, it will not be a living trust anymore. It will be called a testamentary trust. And this kind of trust is created in conjunction with a will. So you would have to have a will and this trust that's created from a will. So for example, if you have minor children and you have houses and assets and you're worried that, if I pass away or something happens to me and my kids are still young, I don't want my kids all of a sudden to have all these assets. They're not going to know what to do with it. Kids, like, they don't know what to do with a house or a car or whatever assets you have. So what happens is, if you don't want to create a trust now, you can create a trust through your will. So you can say, upon my passing, I want a trust to be created, and I want this person, whoever it be, it could be your brother, your sister, your spouse, whoever it is, you can name them as the trustee, and then they can manage your trust for your minor children. So you can say, okay, my brother will be the trustee, for example, and he will manage the trust. And every month when the rent comes in from this investment property, he will use this money and pay for my children's living expenses. That way your kids don't get a big sum of money all at once. They get monthly expenses. They get monthly amounts of money to pay for their expenses. And then you can also add a term that says when they turn 18 or when they turn 21, then the house will be changed into their title, and it doesn't even have to be an age. You can say when they, get married and have kids, then they will get this house. And if they don't get married, they don't get this house. It's a great way to get kids to do certain things if they want to get the assets. Otherwise, they don't get the assets if they don't do what you want. So that is a testamentary will, a testamentary trust. It's created through a will. It's not created when the settlor is living. Now, funded versus unfunded. So a lot of people, their trusts are funded. Funded means that when you create it, you immediately put assets into it. But if you don't want to put any assets into it, you can create an unfunded trust. It's a trust that's empty. There's nothing in it. It's just a shell, and it's ready for you to put property in it whenever you're ready. So I have clients that say, I haven't bought a house yet, but I know I'm going to buy a house this year. And I want the trust to be ready once I close escrow. So they can create an unfunded trust first. And then when they close escrow or, whenever they're ready, then it's when they close escrow, they can immediately put the title of their asset, of their real estate, into the name of the trust because the trust is already created. So that's the difference between funded and unfunded trusts. You do not have to have assets immediately ready to put into a trust. You can create an unfunded trust right now, and then you will be prepared for when you're ready to put assets into it. So that's the difference between funded versus unfunded trust.
Elizabeth, if you have an unfunded trust and you have a business, and you want to put let's say you buy a property with your business partner, do you create a separate LLC or do you put it under the company? I mean, usually what I've heard is you do a separate LLC, right?
So you can
how would that work?
Yeah, you can put companies into trust.
Okay.
Yeah, and for companies, right now, like you and your business partner might be the two owners of the company, but that means if someone passes away, then you have to have a will, right? And then if you don't have anyone, if your beneficiaries are minor children, your minor children are not going to know what to do with a business. So the benefit of putting it into a trust right now is that you can designate someone to be the trustee. You can designate, for example, your business partner to be the trustee and say that he has to manage the business for your minor children until they grow 18 or become adults or graduate college. But your business partner, as the trustee, he will have this fiduciary duty to manage your business for your minor children, and your minor children will be provided for, and they don't have to worry about running the business or having to do an adult's job. So that's the benefit of putting your business into a trust right now. Does that answer your question?
Yes, it does. Thank you.
Awesome. Thanks for the question. Okay, so if anyone else has questions about trust, feel free to ask. Otherwise, one more question, Francine?
Yes. There is a question about revocable trust, if that's shielding from personal lawsuit.
Yeah. So irrevocable trusts are the ones that protect from lawsuits.
What about revocable?
Not.
Revocable, not.
Yeah, if you have a revocable trust and someone sues you, the creditor can still access any assets you have in the revocable trust. So it has to be an irrevocable trust. But you have to have your irrevocable trust set up early on. You can't wait until someone has already filed a lawsuit against you, or they're almost, close to getting a judgment, and then you set up an irrevocable trust. Then the judge can easily set it aside, saying that it's like trying to cheat the system. So you got to set it up early, ahead of time, preferably before the lawsuit is filed, right? So I have clients who maybe they hit a pedestrian and they feel like that pedestrian is going to come and sue them for personal injury. So they hurry up and create an irrevocable trust. They put all their assets in, and then by the time the lawsuit is filed, all their assets are protected. Okay, so timing is super important.
Okay.
So we'll take, any other questions?
There's another question, says, is a written document and notarized considered a legal trust or will?
So that's a great question. Okay, so getting a document notarized, the whole purpose is to prove that the signature does indeed belong to that person. Okay, so having a will or trust notarized is not a requirement. Having the two witnesses is a requirement. But if you don't notarize it, it's very easy for someone to go to court and contest it and say, this is a fake signature. And then you'll have to go through this long extended process of getting a signature expert, a handwriting expert to come and testify whether it's a real one or not a real one. So just go get it notarized. It's, notary is like $10 or $15 a signature. It will save a lot of hassle.
Okay.
All right, thanks for all the questions. So I'm going to spend the last couple minutes going over our last topic, which is powers of attorney. Okay, so power of attorney is different from a will or trust, but a lot of times it's executed in conjunction with a will or trust. Because if you're going to an attorney and getting it done, usually the attorney will just have you do the power of attorney. So what a power of attorney does is it authorizes an agent, a third party, to act on the person's behalf. All right, and so that person who is issued the power of attorney can go and sign legal documents on their behalf. They can open bank accounts. They can withdraw money. They can pretty much do anything that the power of attorney allows them to do. And there's different powers of attorney. There's one that are specific and ones that are general. The general one allows the power of attorney to do pretty much anything. The specific ones will specify exactly what the power of attorney can do or cannot do. So for example, if you want your sister to act as your agent to close escrow on a property, you can give her specific power of attorney to do all actions related to escrow of this property, but nothing else. She won't be able to touch any of your other assets. But if you give her a general power of attorney, then she'll be able to make decisions for you on everything. And in the power of attorney, there's what's called advanced medical directive, also known as medical power of attorney. So this is where you can specify what happens when you're on the hospital bed and, you know, say like you get in a car accident and you can't talk, and the doctor is, you know, asking your family members, you know, what do they want to do with you? Do they want to pull the plug? Do they want to, you know, do surgery? You know, those things. You know, I had a client once tell me, oh, I don't need a power of attorney. The doctor will just make decisions for me. No, the doctor will not make decisions for you. They will look for who has the power of attorney and go to that person. And if you don't have a power of attorney, which some people don't, then what happens is family members end up fighting in the hospital. Like they're already so distressed by what's happening, and now they have to fight each other in the hospital because they don't agree on making a decision. You know, if someone wants to keep you alive and the other one says no, you know, he or she told me that they never want to be on, you know, a feeding tube and they would rather die, then they're going to be going at it. So save your loved ones the trouble and make your decision early on so that they don't have to be guessing what you would like to do. Okay, this gives them clarity as to what your decision is when you're not able to communicate it. So that's a medical power of attorney. All right, so any questions about power of attorney or advanced medical directive? I know we just have some few minutes left, and I want to leave some time for Frank as well. So I will leave the last few minutes to Q&A.
Anybody has any questions? Ask now. Oh, here's one. What type of assets are recommended to fund into a living trust?
Okay, so pretty much any assets can be put into a living trust. You can put in real estate, you can put in vehicles, bank accounts, checking savings accounts. You can put in stocks, bonds, 401ks, pensions, pretty much anything that's under your title can be put into there. There are some assets that already has beneficiaries named. In those cases, then you don't have to put it in there. For example, life insurance policies already have beneficiaries named. You know, so unless you want like a trustee to manage it, then you don't need to put it into a will or a trust. Same with like some bank accounts. You know, some banks will allow you to name beneficiaries who can access your accounts in case something happens to you. In those cases, you also don't have to put it into a will or trust.
Very good question. All right, I don't see any more questions. Why don't we give the floor to Frank for him to give us the market update. Elizabeth, I wanted to thank you so very much. I have to tell you, I've heard a lot of estate planning presentation. This is the best, the most clear and easy. Great, thank you so much.
You're welcome. It's my pleasure.
Thank you. All right, Frank. Frank is now going to give us the market update.
Okay. Hey, everybody. This is Franklin. Thank you for giving me the floor. And that was a very, very awesome presentation by Elizabeth. I feel that even though I've been in the business for so long, I still learned something new from her. And since we're on the topic, I figured we might as well just stay on it. So when I help clients do financial planning, tie into the trust setup, I noticed that usually when we do financial planning, there's three different age groups. There's the group from 30 to 40, 50 to 60, 70 to 80. And you can see that usually from 30 to 40, this group, they usually don't have a trust and they're just kind of flying blind. So definitely if you or your kids, they're at this age group and they don't have a trust, definitely reach out to Elizabeth. I think that's much needed, especially when this age group are starting to have kids, right? You want to protect not just one generation, but two generations. And if you're in the baby boomer age group, most likely you have a trust, but also there's a potential chance that your trust is probably more than 5, 6, even 10 years old and needs a lot of updates. So definitely, again, that's a big common issue I see when I help clients do their financial planning, is that their trust is way outdated. For example, one of the clients, their successor trustee, 2 of their successor trustees have already passed away, right? But they haven't updated it yet. So definitely that's something to look at. And then obviously when you're 70 and 80 years old, when you're in that age range, you're thinking more of wealth transfer. And that's when ILIT and all these creative planning comes in. And again, trust is needed here. So that's why I think it's so important for us to have an expert like Elizabeth here to tell us all the ins and outs of it and to kind of give us an idea of how to put it to work. So that's on the planning side. On the market side, for whoever's involved in the stock market, I'm pretty sure if you look at your 401k, it's been down for the past couple of days. And then maybe you're asking yourself, hey, where's it going? Here's a couple things I want to show you. And I know my time is pretty short, so let me show you something here. This is the currency. So you can see US dollar is becoming stronger compared to other currency, meaning that your US dollar is worth more now. And that's a big impact to your wealth. What do you mean by that, Frank? Well, what I mean is when US dollars go strong relative to other currencies, gold price goes down, energy price goes down, stock price goes down. So this is one of the major reasons that explain why the market has been going down for the past couple of days. And then if you look at this is a very complicated chart, but I want to show you that you can see there is a downtrend here and there's a line here. So what I'm telling you guys is in the next couple of days, if S&P 500 breaks below, I would say around 3,100, then that probably means that the market will continue to go down more. So if you're in the market, think of ways to protect yourself. There's many ways to protect yourself. If you're a beginner, you can choose to take some profits or cut some of your losses. If you're more of a pro, you can consider using some hedging strategies. Okay, so that's the market update. And then I also want to inform all our audiences that we got a lot of great information on how to use living trust and also other types of irrevocable trust to protect our wealth. This Saturday, we are hosting a seminar, 10 a.m. in the morning. It's going to be a case study. We will be presenting real life cases on how we use multiple trust designs to secure our clients' wealth, and then also protecting not just one generation, but 2 to 3 generations. And for more detailed information, feel free to reach out to us and we'll definitely register for you and send you out the link. Thank you very much.
Thank you very much, Frank. If you are interested at the Saturday sessions, please give me your name and phone number or email address and we'll send you the link. Let me tell you, you don't want to miss Saturday session as well, because now Elizabeth has explained to us how the living trust works. Now we're going to put that into action. Okay, great. Well, ladies and gentlemen, it's almost 8 o'clock. We're waiting. There are quite a few people waiting at the waiting room for our next session. Great to have you all. I look forward to see you again next session. Thank you very much. And if you have any question for Elizabeth, you're welcome to reach out to her. I will save the chat, and if you don't, her email address is in the chat area. If you don't have it, call us and we will give it to you, okay? Thank you.
Great job, guys.
Good
Thank you
night.
for everything.
Tony, thank you, everybody.
Good job.
Thank you for
you.
coming.
Thanks. Bye. Let me see. I'm saving the chat. Thank you, Liz. That was wonderful.
You're welcome. I hope it was clear enough for everyone to understand.
Very, very clear.
Try to break
Very-
it out into very basic information.
So very good. I love it.
I'll be right